All right, we are live today. Thank you so much, everyone, for joining us. We are going to be discussing an 11th Circuit FBAR penalty case. But before we get to that, and I have a whole introduction, but before we get to that, we have an important, incredibly important announcement from the great John Richardson, an emergency announcement, as he says. So I am going to let him explain exactly what's going on before we get into this. Some news for the election cycle, John. So go ahead, take it away, John.
I'm sure that this is likely to fall on deaf ears, but yesterday I actually invested the 4 to 5 hours of my life listening to the DA a vote-a-thon, if you will. Okay, where they
The
have
Democrats abroad. Okay,
Democrats
yep.
abroad, Dems abroad, right?
Yep.
That's their Twitter handle. Where they have all these people going on about this is their vote from abroad, get out of the vote sort of thing. Okay. But what was, expected, I expected this, but it still shocks me every time I see it. Listening to 4 hours of encouraging Americans abroad to vote without a single, not a single recognition
of one issue.
Of what the Democratic Party has inflicted on Americans abroad over the years, okay, in the form of FATCA, and recently, by the way, wanting the escalation of guilty, et cetera, okay, what they continue, and their tax, what they continue to inflict, not only on Americans abroad, but I'm going to extend it. What they're doing is they are inflicting this stuff through citizenship taxation on the residents of other countries, your friends and neighbors. Not once, with the exception of Rebecca Lammers, okay, who, as you might expect, is the head of the DA tax group, whatever they're called, okay? And, so she came on at the end of the last minute or so in a group, okay, properly insulated and watered down, because she was one of about 6 or 7 people who were part of the group who attended the convention. She and she alone, although it was definitely watered down, and I suspect deliberately attempted to mask the message on the part of Democrats abroad, talks about, at least acknowledges the tax injustice and everything else to Americans abroad, and then goes on to make the claim that, well, eventually they want to move toward residency-based taxation. And she ends with, but next week, she and her people will be in Washington knocking on congressional doors, et cetera, all of which is good. Okay. And
so John, just to correct me if I'm wrong. So we have Democrats abroad, the group that's supposed to represent Democrats abroad. Okay. And the number one issue that affects people, anyone abroad, and the most nasty thing is citizenship-based taxation. And Rebecca Lammers has been doing good work, and I hope we can convert her completely. She's been doing good work. She's been out there trying to represent, and I think really listening to the concerns. I do believe she's actually really concerned about these issues. So she testifies there. And did you tell me that you actually felt sorry for her?
I felt sorry for her.
Why is that? Why did you feel sorry for Rebecca?
The only voice of rationality. She is an island of sanity and realism in an ocean of sheer madness and craziness, where there's only 2 themes to the thing. First of all, why do you vote for the Democrat? There's only one reason: to keep Trump from being elected. They don't have a platform, nothing. It's just that they want to be in power, and they figure the way to do that is to say, well, don't vote for Trump, right?
All right, so there's just the anti-Trump party, yeah, and then whatever.
Democrats, but broad, okay, a seminar aimed at Americans, but broad, okay, with the exception of Rebecca, not a single recognition of anybody that might just get out and vote. Now, I do agree that Americans should vote, and I thank Rebecca for explaining why, that then she can go into congressional office and say, well, there's voters here and there's voters there. But you mark my words, if you use your vote to vote for the Democrats, any Democrat, anywhere, all you are doing is giving them a license to continue to not recognize this as a problem, and you are lessening the chance of any kind of solution to this.
Yeah. That's it.
I mean,
Thank
it
you.
was
Yeah, go ahead.
shocking in its depravity. It was shocking.
It's shocking. Oh, it is so. All right, there it is. So, thank you, John, for that important update. We really don't want to be, and we try not to be very political on this, but you're just basically saying, hey, look, this is a suicide pact.
This is
They're
not
they're they're intentionally ignoring you, and you're going to say, yes, please ignore us, please continue to ignore us. No, it's not even ignoring. Ignoring would be great, but the opposite of ignoring, they give attention in the wrong way.
it's contempt. It's
So that's just
absolute contempt and ridiculing America. And this is not at all political. When I say don't vote for the Democrats, I'm saying just that. Don't vote for the Democrats. All right. Because,
right.
they, continue to inflict this problem. Okay. This trying to ignore it at the same time saying, we're not going to represent you. We're
Yeah.
not going to recognize your issues. We're not going to talk about your issues, but by God, you vote for us. So the worst thing that Americans abroad could do is to vote for the Democrats. What I'm saying, I'm not saying vote for the Republicans. I'm not saying vote for the Greens. What I'm saying is don't vote for the Democrats. Okay.
Yeah, there we go. All right, well, and we're not telling who to vote for. We're just telling you who not to vote for.
Well, I'm just telling you, this is not political at all, Anthony.
Yeah,
I'm not here, trying to market any political party. I am simply explaining the danger of voting for a group of people who have made it very clear that they support the continuation of policies that will result not only in your destruction, but in the destruction of your friends and neighbors
there you go.
in your country of residence.
There you go.
I mean, it was shocking. I hope you take the time to look at it.
So, all right, well, thank you so much. So there's our introduction. Now we're going to get into the promised subject matter of today. And today we're going to be talking about, and if you notice my title or thumbnail, I have a little bit of a provocative thumbnail. That's it on the video. And I'm saying that FBAR penalties are illegal. Pretty bold statement when we see FBAR penalties actually being assessed in millions of dollars. But actually, if you analyze them, they're illegally assessed. And this is really one of my points of aggravation and shock. And just basically here we are. This is the reality. If you were going to ruin someone financially, I mean, totally ruin them through the most depraved process possible, under the weight of the law, wouldn't you want to make sure there's a law? If you're going to upheld, like the Supreme Court, they're going to upheld, and they have upheld millions of dollars in FBAR penalties. If they're going to do that, shouldn't they really, really make sure they actually have authorization to do so? Now, we saw some good news come earlier this year. We had a case, Loper-Bright, pass, and it basically said, you know what, your regulations have to have some semblance to the law that was actually passed. Because prior to Loper-Bright, Chevron standard applied, and basically was the agency deference, and basically every regulation was a rubber stamp for whatever the insiders in Washington did, whatever they wanted to have. So we have Loper-Bright, but Loper-Bright just came out, and really this has been, if you've been following this channel, my big argument is that 31 U.S.C. 5314 does not mandate an FBAR. We've done plenty of content on that. I put some links in there so you can find that, so you can lay out the entire argument. However, recently the 11th Circuit just upheld FBAR penalties in a case U.S. versus Schwarzbaum. And it was not a good outcome. I wasn't really happy reading the decision, but the great John Richardson sees a silver lining, and we're going to go through that. John has a presentation for it. He sees this possible silver lining here. But before we get to that, I want to go to Keith Redman, the advocate to and counsel to the American abroad. So get his opinion basically on everything that's going on here with the FBAR. And Keith, you read the case.
I did.
So I kind of want to get your layperson opinion. Okay, what do you think about it?
Yeah, where my focus was really on the background of this gentleman.
Mm-hmm.
And, he's not an American overseas or an American immigrant. He spent time in the United States, and he sounds like what I gleaned is that he probably has some type of financial interest or maybe some sort of center of gravity in the U.S. But, or I should say, how do I say this? He got some bad advice from a U.S. tax compliance person, and he also did not divulge all his foreign bank accounts. He only divulged one in Costa Rica. He did not put down anything about any of the other accounts.
Mhm.
And I know that, Anthony, and I tend to agree with you that this whole FBAR thing is a bunch of BS. But just from a practicality standpoint, he didn't follow the rules.
Mm.
So
Oh
he knew
boy.
it.
Well.
Well,
Oh well.
so I know. I mean, he didn't have he didn't. He knew he had the accounts, but he didn't divulge them.
Yeah.
And now he's has to pay these penalties, which I find. Don't get me wrong. I find it unacceptable, the penalties, but he kind of did it to himself.
Yeah.
Is where my view is.
Yeah.
But the other thing I wanted to enforce is that he's not the typical American overseas or American immigrant at all.
Yeah. Yeah.
And that's where my focus is.
Okay.
So that's where I'm coming from on this.
Well, so Keith, then, so we should really, his problem is like, well, you didn't follow the rules, right?
I know. I knew you were going to get on that one.
Yeah, he didn't follow the rules. Well, Keith,
well, that's what the rules are. I mean, I agree. The rules are terrible, but that's what it is today.
Whoa, so. Yeah, no, he didn't follow the rules, and that's the problem right there. Because what are the rules? What are the rules? And the rules are the rules. The rules, Keith. You can find those in the law.
Sorry, say that sentence one more time.
The rules, and I'm just putting up where the rules are. The rules are 31 U.S.C. 5314, records and reports on foreign financial agency and transactions. So those are actually the rules.
Okay.
The FBAR regulation is made up fantasy land. That's the rule. So he didn't follow the thing that's actually not the law, and that's the problem that we have. Is that, and this is the issue I have, is that people are falling upon their swords. Well, he didn't do the right thing. Well, look, can we just apply the same standard to the government? Because here's just a taxpayer who has no real resources. And I think we're going to do a podcast on when you're liable for penalties and when your tax preparer is. And guess what? Most of the time it's you. Very rare. So people, and this is what drives this is what really drives me nuts, is that people are falling upon their own sword. And he shouldn't have done that correctly. But who is in a better position to know what the actual law is? A taxpayer or someone who's paid, a lawyer who's paid to review this stuff all day, who's working for the government? Yeah. But yet the government, for some reason, can't find this law. I know the regulations point to it. They'll say 31 U.S.C. 5314 mandates an FBAR, and it does not. You go through this, and we covered this exhaustively, and that's not the topic of this, but that is the point. When people are just are oh my God, I did it wrong. Well, can we just ask the government? Is that okay to ask the government to follow the rules? Because they're not following the rules.
Right. And so with this ruling is, why don't they take a look at what these rules are or are not?
And that's kind of where, right. And that's too. Right. And that's where I'm at. It's like, well, hey, look, you guys, this is where I'm at is, again, what I said earlier. You're going to ruin someone. I mean, there's the Supreme Court up in a rope. It's like, okay, what's going on here? Oh, we're here to discuss a $1 million penalty against somebody. Oh, okay. Well, that's a big deal. Wow, it's just an individual, and it represents basically all their entire fortune. Wow, we're just going to take it, and why is that? Oh, because he didn't file a piece of paper. Oh, okay, let's just and I mean, what? Yeah, you're just going to not even stop to think. Wait a second, what is this? What are we talking about? And they won't really analyze the law. They just sort of reference it, and they will make and basically they've adopted Treasury's position that it mandates it. It certainly doesn't. So we've covered this a bit, and I don't want to beat on. I do want to get to John's presentation because it's so very good. So let's get to John's presentation. All right, John, let's add this to the stage here. Mr. Schwarzbaum meets Mr. FBAR in the 11th Circuit. All right, so this is going to be fun. It's going to be fun. All right, John, so let's get into it. Mr. FBAR. Here he is.
Okay. Why don't you go down a slide? Let's slowly go through.
All right.
Okay. All right. So everybody agrees, we've talked about this ad nauseum, that, 5314 on the regs create penalties. They create massive penalties. They create penalties that are out of all proportion. okay, to what was going on. For example, on a willful penalty, it's like, well, for example, why don't you quickly put on the screen 31 U.S.C. 5321? I think it's A5.
Okay, A5.
I think so. Yeah, you go over to go forward. No.
Oh, forward.
Next to 21.
Oh yeah, right. Yeah, I should know that.
Okay.
This is my most browsed page, by the way. These are my.
Yeah, 20, 21. We want to go to 21.
There we go.
All right. So, here's basically, so that's civil penalties. Go to 22. Are criminal penalties in a different section?
Yeah, I think they're up ahead. Yeah, here we go. Right.
22. Yeah.
Yep.
Okay. So we have two levels of penalties, right, for this. And what I want you to realize, okay, scroll down a little bit under the criminal penalty section. Okay, let's see what they've got. Actually, sorry, go back to 21. What we want is the civil willful penalty, I think, is what we want. Okay, keep going down. I think it's section 5. Yeah, here we go. Okay, the amount of the penalty. Now, you see it says, except as provided in some paragraph C. Go down to C, because I think that's the civil willful. Go down to C. Yeah, here we go. Yeah, I've got it. Okay, stop there. To give you a sense of the magnitude of this, right, what it says in the case of any person willfully violating, in other words, willfully not violating the form. Here, get it back.
Sorry, yeah, sorry about that.
Okay.
Got a little mouse happy there. Sorry, John. Killing your flow. There we go.
Okay, so notice that it says the penalty shall be increased to the greater of. Greater of. Okay, the greater of $100,000 or 50% of the amount determined. Okay, now the amount determined is the balance in the account. Okay. Now, Anthony, let's imagine a situation where somebody has an account balance of $20,000 and they failed to put that on an FBAR. How would you interpret the penalty rule?
They have $100,000 penalty.
Exactly. Now let's pause there for a minute. Okay. So what's happening here very, very clearly, and this has always been a concern, but after the Bittner decision in March, right, which ruled that the non-willful penalty is based on the form and not the number of accounts, there has been concern. I don't know if this will really happen, but I think it's a legitimate question to ask whether the IRS might sort of, reflexively assert willful penalties, right? Because that gets them out of the scope of the Bittner decision. And once you're right, so you've got. This is really shocking. So just think about it for a minute. You have a balance of 20,000, that you've forgotten about, that's just been sitting there for years, not even collecting interest. Okay. And they're gonna assert penalties of $100,000. Now, before we get to Schwarzbaum, let me just say this: that the decision referred to 3 accounts that he had with balances in the $20,000 range, where the IRS asserted penalties of $100,000. Okay. He had a number of accounts, but 3 of them fell into that precise category. And that's going to be important for our discussion. Okay, now let's go.
All right, so John, and this is where my mind goes, because I know how penalties are being assessed now, and how it's there, but what can they do, and what's possible too, and something we didn't mention is that right now they will assess 1 year of FBAR penalties, but there's nothing to stop them from assessing multiple years. And really, basically what they have open when they find you is about 5 years. So they have, there's a 5 year, basically a 5 year time to assess the penalty. So let's just say you have an account that has been exactly $1 over $10,000. You have one account that has been worth $10,001 USD every year for the last 5 years, and you did not file an FBAR. And let's further suppose it didn't even earn any interest. It was just a bank account. Do you see how that $10,000 and a dollar could be now $500,000 in penalties.
Yeah, well, it's a 6-year statute of limitations. So
Right, but effectively, they really will only get you about 5 years by the time they get you. Right? That's that. Yeah, yeah.
Oh, that's exactly right. I mean, I think that this gives new meaning to the word draconian. But you know, this is the American way.
Yeah.
Okay, I mean, there's no question about it. And I've known people who renounced U.S. citizenship because of the FBAR, and they're worried that as they age, they might, forget to file.
You forgot to file it, and therefore you should be ruined beyond, right? Because you didn't file this piece of paper.
Now, I don't know there's any way to be fair about this because everything about it is unfair.
Yeah.
But I think to be more objective, or to be objective in the enforcement, I mean, to be sure, a lot of people are getting hit with this stuff, but I mean, they're not just, walking up and down the street, banging on doors, looking for, people with unreported accounts either.
Yeah.
But the problem is the laws are on the books, right? Okay. And this is very important, to understanding the Schwarzbaum decision.
Great.
Okay, let's go back to, the beginning here a little bit, right?
Right.
Now, there are people who have an awareness that the United States has a constitution. They just don't understand the real constitution, the Internal Revenue Code. But, for those who, look at the more traditional idea.
The claimed constitution. There we go. The claimed constitution. We'll call it that. Yeah.
It has an 8th Amendment. And this is exactly what it says, okay? Excessive bail shall not be required. They're clearly in violation of that. But contextually, nor excessive fines imposed. Nor excessive fines imposed, right? Or cruel or unusual punishment, right? So these are things the government, supposedly can't do, right? I mean, we know they do them. But the issue here is, I mean, Anthony, do you think that imposing, which they did in Schwarzbaum, a penalty of $100,000 for failing to report an account with a $20,000 balance, do you think that's an excessive fine?
Well, if that's not an excessive fine, what would be an excessive fine?
I think that's right. I mean, that's far more than even the value of the account. You'd be better off under, civil forfeiture, where they just take the account.
Right. You're right. You'd be better off if someone stole your money. So that doesn't. Right.
So I agree with you. It's hard to make a case that that's not an excessive fine. So the question, right? I mean, let's say that you're a government lawyer that, and your job is to, defend any claim of the United States that violates the Constitution. What would you argue? How would you argue, Anthony, as a lawyer, that no, there's no excessive fine imposed? I mean, how would you argue that? You say, well, hey, I mean, you just charge the guy $100,000 as a penalty, $100,000 on a 20. How would you say, well, no, it's not an excessive fine?
Well, here's the thing, because I have to put on my evil suit. Hold on. Okay, here it is. Okay, here it is. I have a problem arguing it's not excessive. So what I would do is like, oh, it's not a fine. That's
exactly.
I say, oh, it's not a fine. Hey, right? Hey, you can be right there. You go.
Exactly. It's not a fine at all. It's just an administrative charge to administer the FBAR statute, right?
That's all it is, right? There you go. Oh, man. Yeah, exactly,
That's
man.
what it is.
Sorry, what did you say, Keith?
I mean, just layman guy here. It's not a fine. It's an administrative charge.
Keith, I want to ask you a question. We've been doing these talks, these three of us, for about a year. Have you ever known me to distort reality or exaggerate even once?
No, but I'm just, no. It's just,
it's not a fine.
I'm gobsmacked. That's all.
That is exactly what they argue. Now that's a bit of prologue here. Now let's go back to the presentation, Anthony.
Okay. Yep. There we are.
Now, so let's get on now to the next thing. Okay, we don't have a lot of slides today, but they have a lot of sort of meat to them.
That's right.
Now,
yeah.
One of the things that I find interesting is that the number of older people, sort of 80 plus, who get caught up in this FBAR stuff. Right?
That's what it is, John. That's what it is. And that's who they penalize the most.
So let's start with a woman in the Boston area in Massachusetts by the name of Monica Toth. Now, the situation with Monica was Very similar, actually, to what Keith described with Mr. Schwarzbaum. Monica Toth, and these are just the facts that you read in the court decision. Okay, I don't know any of these people, so we accept what they say. She's an 82-year-old woman who basically her family escaped Nazi Germany, went to Argentina, where her father was, a successful businessman. At some point, she moves to the United States in her life as a young woman. The father dies, and leaves her, I don't know, a few $1 million, and she leaves it, I think, in a Swiss bank account, which is where he put it, by the way, for her. He put this into a Swiss bank account, so she just had it. And and she's somebody who goes to the library and prints out her tax forms and does her tax forms every year. And of course, what kind of that's your first clue, okay, that she's not very practical. But anyway, it's part of an audit, or she learns or something about this FBAR thing, and she of course tries to come into compliance. I mean, this is what's interesting, right? Very often it's the attempt to come into compliance. Now, her view of this, of course, was that, as is the view, and I think probably the reality for most of these people, is they didn't know anything about the FBAR thing. I think it's a great mistake to fill out any of these forms on your own, for anybody listening, okay? Or at least get somebody to check them, all right, who's used to this stuff. But anyway, so what they did was they tried to impose willful FBAR penalties on her. Now, it may be that there was one of these Swiss, what was it? What's that Swiss bank? It may have been, had to do with that particular Swiss bank as well. But in any case, so what then happened was that she didn't take it all that seriously. She tried to represent herself, and eventually, another great mistake, and eventually the Massachusetts court sanctioned her for not complying with the rules of procedure. But fascinatingly, and I think that this is grossly improper, the sanction was a finding of willfulness, right? In other words, the issue in the litigation was,
oh my God.
and the judge sanctioned her by essentially deciding the issue of willfulness in favor of the government, okay? I mean, this is, you can't make this stuff up, right? Okay?
Oh my God.
Yeah. So what then happens is that then I think she gets legal counsel finally. But I mean, you need legal counsel early, not
early, right? It's early. You don't get it. It's harder later, guys. You gotta kind of get on top of it as quick as you can. And I just say that if you are, and we are, I do pick up a lot of cases from people who have a tax professional, and every single time, people have their gut saying, I don't think I got the right guy. I don't have the right guy. If your gut is telling you that, you got to reach out. You got to reach out. Schedule time to talk, because you could be making, and I love when I stop people from making terrible mistakes, and I just feel my stomach turns when I see it's, it can be really too late. You can really put yourself in a box. But if you start early, you can avoid a whole bunch of problems if you do it right. So yeah. Thank you, John.
The bank, by the way, was UBS. I just remember the Swiss bank UBS. But in any case, so what then happens is it goes to the First Circuit, which is the Federal Court of Appeals for that area of the country. The issue, or at least one of the issues, if there were more issues, the primary issue was whether the grossly disproportionate penalties, the willfulness, violated the excessive fines clause, right, that we just saw a minute ago. Now, the First Circuit ruled that it did not violate the excessive fine clause. So, I mean, understand this, right? There's, they have the excessive fine clause right in front of them, and the court rules, no, it does not. And the reason had to do with exactly the things that, I was engaging with you at the start, that no, it's not really a penalty. It's sort of an administrative remedial thing,
Oh my God. Oh my God.
Okay.
I mean, just disgusting word games. Disgusting.
Well, it's incredible. But let's continue now to the next slide. Now, this is taken up at this point by a group of public interest lawyers who's, and I think they were great. So I'm embarrassed to say the name escapes me, but this you can find all this if you're interested in the case, who attempted to get this to the Supreme Court in a certiorari writ, okay? In other words, trying to get the Supreme Court to hear the case on precisely the issue of whether these massive FBAR penalties violated the excessive fines clause. Okay, are you with me?
Okay.
Now, well, you know, and I think most people know, it's very, very difficult to get the Supreme Court to hear a case. I mean, I'm actually surprised that they heard the Bittner case. I'm surprised they heard a transition tax case, you know, et cetera, because I think that this is somewhat unusual. In this case, the court rejected the petition. In other words, we will not hear this case on the basis of whether these FBAR penalties are excessive fines under the Eighth Amendment. Okay. Now, what I would like you to do, if you would, Anthony, is click on the link to the post that I wrote about it, because Justice Gorsuch dissented on the decision to not hear the case and wrote his reasons why. And this is pivotal to what happens in Schwarzbaum. So if you look at the bottom there.
Yep, I got it. Let me just get that slide up. I got that slide. Let me add that. Let me add that there. Let me get this here. Yeah, and if you are looking for all the links, I did upload John's slides to Google Drive, and you can find the link to that in the description on YouTube. And also, I just did tweet that at.
Okay, now go to the bottom. Okay, because I actually included Justice Gorsuch's dissent, and I think we need to look at this. Okay, keep going right on down. It's at the end where I just included.
Oh, way down. Okay,
here
we go. Okay, yeah, here we go.
Here we go. Now pause. Okay, now I would like to actually. I know this is going to take 2-3 minutes. Okay, but I think it's worth actually paying attention to what Justice Gorsuch says here. Okay. I mean, now just think about this, Anthony. Okay, mostly, most cases, these cert petitions are denied. Just that's it. We're not going to hear it denied. This was denied, but Justice Gorsuch finds the denial so offensive, okay, that he writes a separate decision. Now,
wow. That's
now neat. I'm going to read this through. I want to read this through because these are the facts as understood by the court. So I mean, there's no disagreement on was this true or that true. These are the facts the court was dealing with, whether true or not. In the 1930s, Monica Toth's father fled his home in Germany to escape the swell of violent anti-Semitism. Eventually, he found his way to South America, where he made a new life with his young family and went on to enjoy a successful business career in Buenos Aires. But perhaps owing to his early formative experience, Ms. Toth's father always kept a reserve of funds in a Swiss bank account. Shortly before his death, he gave Ms. Toth several $1 million, also in a Swiss bank account. He encouraged his daughter to keep the money there just in case. Miss Toth, now in her 80s and an American citizen, followed her father's advice for several years. However, she failed to report the foreign bank account to the federal government as the law requires. Miss Toth insists this was an innocent mistake. She says she did not know of the reporting obligation. And when she learned of it, she says she completed the necessary disclosures. The Internal Revenue Service saw things differently. Pursuant to 5321, that's what we had up earlier, right? The agency charged Ms. Toth with willfully violating 5314's reporting requirement and assessed a civil penalty of $2.1 million, half of the balance of Ms. Toth's account, plus another $1 million in late fees and interest. In other words, they're trying to take the whole thing.
Right.
Now pause for a minute. This is the American government. Okay, this is for real.
This is for real, right?
Okay, I mean, this is so. I mean, you can't even make anything up that I think comes close to the close to the extent of this. We'll talk about AARP.
Yeah.
Let's continue on now. Now, next, initially, Ms. Toth sought to represent herself in proceedings challenging the IRS assessment, but that did not go well. Yeah, understatement. Ms. Toth engaged counsel to argue the IRS assessment violated the excessive fines clause of the Eighth Amendment. This is clearly in the context of the appeal, but the First Circuit rejected this line of defense. And here we go. It held the Constitution's protection against excessive fines did not apply to Ms. Toth's case because the IRS assessment against her was not tied to any criminal sanction, one, and served a remedial purpose. All right, now that's
Does anyone like feel like boiling tar and getting like that? That's really boiling. I feel like boiling tar and getting some feathers. It's just, yeah, this is much.
This decision is difficult to reconcile with our precedents. We have recognized that the excessive fines clause traces its venerable lineage to Magna Carta and the English Bill of Rights, blah, 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 blah. Okay. Now, let me just go to the next paragraph here. Nor is a statutory penalty constitutional because it serves a remedial purpose.
Right. So what?
Really,
right.
Notion of non-punitive penalties is, going on, blah, 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 blah. Okay. Now, so essentially, let's go to the end now. What he's saying is, okay, for all these reasons, taking up this case would have been well worth our time. Now, here he's throwing this out to the lower courts. A message, a bulletin from Justice Gorsuch. As things stand, one can only hope that other lower courts will not repeat its mistakes. Well, the 11th Circuit, okay, which is where we find Mr. Schwarzbaum, is a lower court. Yes. So now let's go back to my presentation. All right, now here, let's go on down now. Next slide. So here we go, and that's my tweet. Mr. Schwarzbaum meets Mr. FBAR on the 11th Circuit. Now, I had a few things on Twitter about this, but one of the things that I find very interesting about this, I think it does matter, is that where the one way these cases overlap is that these funds, okay, Schwarzbaum, all the indications are that he was living off his family wealth. Okay, right. There's no indication that he had any independent source of income. Point here is that both of these people received this money from parents, right? And these parents were not subject to the U.S. tax system, so this is not a question at all.
Right.
Somehow hiding taxable income. Okay, although maybe there was some interest after they received it, but that's a different thing. That's a different thing from running a business, to hide it, etc. I mean, this was just honestly earned money in another country that was gifted to these people, right? And of course, I'm not going to say what I was about to say. All right, continuing on now. Now, what happened in Schwarzbaum? I want to give you what happened. Okay, now I noticed, Anthony, in your YouTube description when you blasted this out a couple days ago, you were focusing on the fact that the court, the 11th Circuit, really upheld massive, I think it's like 13 million in FBAR. Can you imagine this?
Yeah.
Farm, and that's terrible.
Yeah. No, and you know what? And I'm realizing there's a common theme here too, between Schwarzbaum, Toth, and one of my first clients. And this is what I would say too, because earlier you saw me. I'm just going to insert this now, John. Earlier you saw me. Shouldn't AARP advocating for the elimination of FBAR penalties? Well, one other group I'd add, because here is the thing that is a common fact pattern. I had a client with pretty much the essential same facts. She inherited her family left France due to the Hitler being in Paris. She moved to the south of France to live with her uncle. Then she eventually moved to the U.S., lived in Queens, and she inherited her uncle's account at Credit Suisse, and it was about $500,000. And she didn't know, and honestly, she had a lot of mental issues. She was electroshock therapy. She had a lot of issues. She was had dementia, and it wasn't good. And luckily, we got her into, we did get her into a program, and we argued for lower penalties, and we were actually very successful. We did, but they still imposed, it still was $40,000, even though the woman didn't even know what day it was. But the common fact that we see is that, number one, if you're elderly and inherited money, the chances of you getting the full brunt of the IRS are shocking. And the amount of Jewish clients, Schwarzbaum does not look like an Irish last name to me. I'm going to assume that is Jewish. The amount of Jewish taxpayers who've inherited accounts overseas that get assessed wild FBAR penalties, it's really a theme. It seems to be a theme. And I'm like, well, isn't there an ADL? I mean, shouldn't they be out there? Isn't this a little anti-Semitic? Because if you look at the application of the law, or the non-law, because it's not the law, if you look at the application of how the government works, you can see a clear trend about who the IRS abuses: the elderly, and Holocaust, and people who inherited money overseas.
There was that case, I can't remember the guy's last name, but the guy was like 90 something, close to 100 years old. It was a similar case. They went after him.
Right. Yeah. And it's kind of, if you look through, it's like, wow, there's a real common theme here. And I just find it interesting that no one's interested. No one seems interested that people are losing, elderly people who have dementia are losing their fortune, of many of whom seem to be Jewish. And there seems to be a large Jewish lobby in America, but boy, they don't know about it. Oh, who's that? Hey, what are you talking about? Very, very fascinating. Very, very fascinating about what's going on.
So anyway, Schwarzbaum, by the way, he's born in 55. Okay, so he'd be what? 60?
Okay, so he's still a young man. All right, he's still somewhat.
He's unusually young to be involved in this. Okay?
Yeah, right. Actually, he is actually usually someone born in the 30s is who they're going after. Yeah.
Now, so Anthony, you're correct that one can view this case as, and you're absolutely right, okay, as one more example of the unjust confiscation of these assets. I mean, clearly, it's so obvious, okay, that this is they're just being sanctioned for having money that has no illicit purpose, was never subject to U.S. taxation, and just not reporting it to financial crimes. I mean, it's simply unbelievable. But this particular decision, now, let me tell you where I'm going with this before we go there, is that the bad news is, as you point out, Anthony, that there is no way, okay, that this can be described as anything but an unjust confiscation of assets.
Absolutely.
The good news is that what the court did was it looked at all the accounts and analyzed the reasonableness of the penalty on an account-by-account basis. And there were 3 accounts that were more or less the example that I gave to start the thing off, with account balances of, I think a couple of them were 16,000, but let's say 20,000, where they imposed penalties of 100,000. And what the court actually did was rolled back, or said, got rid of the 300,000 penalties on those accounts, rolled it down 300,000. Now, I agree with you that I doubt very much that may, was much consolation to Mr. Schwarzbaum, particularly since I suspect that his legal fees were close.
Oh my God, I know, right?
For this. But what's very, very interesting is this: that is it was a huge loss for Mr. Schwarzbaum, but it's a huge win for the general public, right? Because what it says is that FBAR penalties are subject to 8th Amendment scrutiny under the excessive fines clause.
Oh, so these fines are actually fines. Okay.
Absolutely. Now, we'll look at some things from the decision, but the court specifically, one of the things the court did was said, no, these are fines. What, are you kidding me? Okay, and then it said, now we're going to analyze the appropriateness of each of these fines in relation to each of these accounts.
Okay,
now,
then how did we get this result?
Okay, they said clearly excessive. They were not prepared to say excessive on the other ones, which I agree is a problem. But I think the key point here going forward is that this is the first time that I'm aware of that a court, or at least a court of any significance, has ruled that
Yeah,
FBAR penalties are
that's
in
right.
subject to the Eighth Amendment, and that
That
is
is right.
so. It's a big loss for Mr. Schwarzbaum, but I think a big win for taxpayers generally. Does that make sense to you?
Well, but John, if that's true, that it is subject to the excessive fines clause, well, then how could this not be an excessive fine? How did they're
Well,
okay?
yeah, I agree with you. I think the fines are excessive regardless. Okay, and maybe that's the next round. The next unfortunate victim in the litigation. But the point I'm making here is this: that in order to be able to make the argument that the fines are excessive, there has to be a law or an acceptance that FBAR penalties are subject to the excessive fines clause. Okay, and that's what this decision gives us. So what we have now, right? Essentially, Mr. Schwarzbaum fell on the sword. Okay, but to protect, if you will, or at least provide the opportunity for people down the road to argue that a penalty violates the excessive fines clause, right? And that's great. Okay, that's really really good. And so it's the opposite of Bittner. Bittner was interesting. Bittner was a big win for Bittner, but as I made the point many times, it was actually what people are claiming as a 5-4 win for Bittner. That may be true, but it's really a 7-2 loss for taxpayers generally, because
Yeah.
the court, all of, the 7 of the judges ruled that this is just a matter of statutory interpretation, meaning that Congress, the government can take your money if it wants to. Okay, this is the opposite, right? This is where Schwarzbaum gets hit hard, but there is a silver lining here for people generally. Now let's go to the next slide. Now, if you want to move over briefly to click on the link there, this is the actual decision. Keith, I saw you had this in your Facebook group. You had the wrong Schwarzbaum decision there.
I did. Okay.
Schwarzbaum's been, this is a long going thing. But in any case, I think we can get the decision up, and we'll go to the bottom. We're not going to read it, but just sort of get down to the bottom. There's a lot going on in the decision, but what he says is, yeah, you're going so fast I can't really read it. But okay, where did he say? Okay, hold on a minute. Ugh. Yeah, I can't scroll the thing myself. All right, maybe this wasn't a good idea to go over to the case, but essentially, keep going. Okay, this is going to be too difficult, I think, to find the thing. I commend the decision to everybody, but I think just looking at that, part of the problem is that it's difficult to read this stuff. It takes a lot of time, and frankly, most people will never read it or understand it. Okay, but the decision, although ruling against Schwarzbaum mostly, says, I think, the following, right? One, FBAR penalties are subject to the excessive fines thing. And another thing it says is that in concluding, all right, that this was excessive and not remedial, for example, the government never offered any evidence that it cost them any money, to assess this against him. There was nothing. They just assessed the penalty. But anyway, that's sort of the bottom line. Now now what does this mean contextually? Let's pause for and ask ourselves, what does this mean? Well, I think this decision means two things, potentially two things, right? Other than the obvious, opening the door, to any lawyer to being able to argue. At least if you're in the 11th Circuit, right? This will increase property values in Florida, which is where the 11th Circuit is, and decrease them in Massachusetts, where the First Circuit is. But it opens the door, obviously, to saying, hey, this fine is excessive, right? Now, but more practically, I think this increases the chances that the Supreme Court will rule on this issue. Because if you look at the rules of the Supreme Court, here, keep going, maybe down to the next slide. I've got this. Yeah. So one of their criteria that will make it more likely that the court will hear the case. This is Rule 10 of the Supreme Court rules, where a United States the Court of Appeals has entered a decision in conflict with the decision of another United on the same important matter. Well, the First Circuit ruled that FBAR penalties are not subject to the excessive fine clause. The 11th Circuit ruled there is. And frankly, I think that the way the judgment was written in the 11th Circuit was to make it very clear that this was in conflict. In fact, it even says that we're conflicting with the First Circuit, right? So I think that this may have been an attempt to help get this heard by the Supreme Court, right? Which is interesting. So we'll have to see who the litigant is in that case. The next thing where I think this has some significance is as follows. Yeah, Isaac Schwarzbaum, a hero of our times. He is. Okay, he really is. He doesn't know it. He never set out to be this kind of person. But he's truly a giant in American history, because when the history of the United States is written and they get to the penalty section, Isaac Schwarzbaum will be noted as the man who forced the courts to take the position that FBAR penalty, that FBAR fines were excessive.
Yeah, John, exactly. And I'll get to, and I just want to share the screenshot of the judgment, because it's just sort of the end of it. And I think this is pretty important of the opinion. I'll share this here, and it's just amazing when you look at this. And so this is why I would say perhaps a hero when you read this, right? So we affirm in part, in reverse in part, and remand with instructions to enter a judgment in the amount of $12,255,813 and to calculate the amount of late fees and interests. Yet the 11th Circuit is saying, you know what, that's not excessive. That's just amazing. It's a fine, but it's not excessive because it's, hey, there's more money in the world than that.
Well, so Anthony, the next area of litigation here, right? And you can think about this if you want to be an FBAR lawyer, right? The next area is, well, what is it that makes a fine excessive, right? Okay, and that the court is completely open on that. Okay, now, when I put this up on Twitter, somebody responded with, well, does this apply to other penalties? And I think the answer is clearly yes. Okay, because one of the things that, the court says, and which Justice Gorsuch has said, is that no, governments cannot call it something other than a fine, to escape this, right? So that would mean, now we've talked recently about the 3520 penalties on the foreign pensions of a third of 35% or whatever it is. I would have to think that this decision opens the door to arguing that is unconstitutional. I really would. I mean, imagine you have $1 million pension. The U.S. government wants $350,000 for not putting on a Form 3520. I mean, that's every bit as bad as this, okay? Every bit as bad, and in many ways it's worse. But the point is, the way the decision is crafted, it opens the door to these arguments, I think, for a variety of penalties, and very specifically, the foreign information return penalties, or a foreign gift for that matter. I mean, imagine, we're going to take 25% of the value of the gift you got. What, are you kidding me?
But it's like, was there any tax non-compliance? No. But hey, we need to know, because hey, we need to know. And
well, for anybody listening to this, and or their lawyers, I think that this case can be used along with Justice Gorsuch's dissent. I mean, interestingly, the decision essentially looked to the Supreme Court, to Justice Gorsuch, and said, "Yes, Justice Gorsuch, we are going to do what you ask. Okay, we're going to deal with this here." And, so I see, I feel sorry for everybody involved in this, right? And
it's just
disgusting. Of course, I think Mr. Schwarzbaum was unjustly treated. But you got to thank the guy, okay, for getting this judgment that clearly, at a minimum, has the potential to cause a lot of litigation costs for the U.S. Treasury, and et cetera. So I think that's where we are. I don't know if you have any particular.
Well, I mean, it's amazing. I mean, the 11th Circuit comes and says, "Oh yeah, no, it is a fine. It's just not excessive." It's just really amazing that they could say that with a straight face. So again, and this is really the argument that you always find. When you what do we think the Bill of Rights meant when we do this? What do you think they meant? They said, "Hey, look, don't impose an excessive fine." So this is a fine, and you're saying it's not excessive. It's like, okay, if this is not excessive, then what would be an excessive fine? Can you tell me what would $10 million be excessive? Would $100 million be excessive? Is there any number in the world? Or are you measuring excessive by how much this money is related? This fine is related to all the money in the world, because it's not. Okay, no, $12 million is a tiny fraction of all the money in the world. So is that the argument? What is the argument? How do we get to the fact that this is an excessive? So if you're saying that it's not excessive, then what you're saying is that the Eighth Amendment didn't mean anything, that the founders went through all this trouble to put an amendment, draft it in there to mean nothing. And that's basically every argument that the government does. They just sort of roll over the Bill of Rights. It's like, well, if they wrote this, what would it look like? What would a violation look like? What would that violation look like? Can you tell us what are the things the Treasury can't do? What will do? Hey, if this is fine, this $12 million penalty is just A-okay, and just administering the law. Can you give us an example of what it would be? Is an excessive fine more? Does it have to involve something other than just financially ruining something? Does it require more of the psyop that destroys someone's humanity? What exactly is it? What does it take to make a fine excessive? That's what I want to know. Is there any limitation on what the government can do to us? And
well, Anthony, look, I mean, the very fact that there's a prohibition on excessive fines means that it must have some meaning. Okay.
Right.
The next, I mean, this is, you're a lawyer, that, these things kind of go step by step, and this is why, justice takes time. But I mean, so what this decision has done, assuming that it stands, okay, is to remove the government argument that somehow the excessive doesn't apply. It does apply. So the next area of litigation, and I would encourage you to think about this, or any lawyer who thinks about this. The next area of litigation seems to me to be focused on exactly what you're talking about. In other words, what is it that makes a fine excessive, right? So more principles. Now, in Schwarzbaum, they began that discussion a little bit. Okay, they talked about, what did it actually cost the government to investigate this? They talked about proportionality. I mean, can it really be? I mean, if you're assessing $100,000 penalty on 16, how can that not be excessive? And then they kind of stop there. As sort of as they say, but there's a general. They actually say this. There's a general presumption that these fines are constitutional. But this is a whole avenue, right? Of now how do we get how do we give meaning to what is an excessive fine? And at least at the moment, I'm tired today, and we've been it's well above my pay grade, at least at the moment. But I do see that's the next frontier in FBAR litigation. And I think that the world in general I think there ought to be an international holiday, Isaac Schwarzbaum Day, where people worship him as the person whose FBAR malfeasance resulted in the 11th Circuit ruling that the excessive fine clause is applied. Right?
Yeah, and Mr. Schwarzbaum, if you are watching this, I want to thank you. And really, your name could very well be in law review or law books that students are reading in 200 years to say this case could really be incredible, and you could be saying like, yep, no, we're in the case that says no, we're going to call a $12 million fine excessive. Yeah, and here's a comment from Melvin too. Like, okay, even if SCOTUS rules that the IRS FBAR penalties are subject to excessive fine clause, the court will likely define excessive when it exceeds the total wealth of the person by a substantial amount.
Melvin, somebody once said I was cynical. I'm not so sure that's true. Let's collectively, people on the ground, the profession, etc., take the position that the job of the legal profession is to work on the question of what is excessive. Okay, and if lawyers don't take this seriously, then yeah. I mean, maybe you have a chance, exceeding the total wealth. But, it's just as easy in life to think that your work will make a difference as it is to think it won't make a difference. And, the easiest way to not move things forward is to assume that you can't succeed with this. All right. And, this is progress. Not as far as as you want, but it has opened a door and made arguments possible that were not possible a week ago. Okay, and Anthony, you say, well, Mr. Schwarzbaum, it might be in law books. I mean, you forgot to say, more importantly, he's on IRS Medic today. What could be better than that?
There you go.
There you go. Right on. There you go. Absolutely. And by the way, I do want to invite any practitioners out there who are dealing with FBAR penalty cases to reach out to me. Really reach out to me because I would love to help. My goal is to get good law on the books here, help you out with any issues that you have. So if you want to reach out to me, and also, I am at Thavon Partners now. And we are just throwing it out there. We are picking up new partners. So if you are looking to join an exciting partnership with really fantastic people, just reach out to me at aparent.com or aparent@irsmet.com. So just think that. Now I want to. Keith has been listening to this. Keith has been listening to this and taking notes. So first of all, what I would say is that if you enjoyed this, please leave a comment below. I've been going through the comments and they're just fantastic. And the comments that we see, and I think a real appreciation that I see for John, really, I mean, wow, I feel so much anger, but my anger is directed. And thanks to John. So, hey, if you like this, leave a comment, just thank John and share it. It really helps. And by the way, when you do that, the algorithms boost this so more people will see it and they won't be stuck with some lousy content. They're going to get the real deal. So help everybody out there by like this. But Keith, so I want to go to you and just say, hey, so what do you think of all this now? What do you think about all this now?
It really makes me sick to my stomach. It really does. I just don't understand. I don't understand how it's not excessive, how these fines are calculated. I mean, it's just the whole thing is absurd. I don't know how else to put it.
Yeah, it's absurd.
It is absurd. This poor guy and Monica Toth and others. It's needless.
Abusive and wrong. Yeah. And I think
not the America that I was told about growing up. And that's what really also makes me sick to my stomach.
Keith, and I'm just sort of thinking something here. A lot of these people, it's like we see the issue, and is that people aren't getting the right advice to begin with, and and I think this is going to be one of the topics you and I were discussing this morning. Is that I think this might be the next one we want to do. Is when is a tax pro liable for the bad advice they give you, and when are you liable? Because that would be an incredible show. Because and I'll just tell you the answer is your tax preparer is never going to be assessed a penalty. It's so rare. So you're on the hook for everything. And so that's one of the things that we have. Like, wait a second, people don't understand this. And so I think, Keith, what they're doing is they're not starting off on the right footing. And so if someone's overseas and trying to figure out what to do, and this is what we do, is Keith, you really are providing a valuable service because you know what the system is. You know what it is. Like, hey, you got to be careful, and you got to be careful that tax industry oftentimes not helping you out, getting the best arguments out. So this is one of the wonderful things you do. And if you are somebody who's wondering what to do and you don't want to really hear a sales pitch from an attorney, maybe, or whoever it is, you want to get real honest advice about what to look for. This is something that Keith does, is reach out to him at US_overseas_advocate@outlook.com. Keith, and what else why should people reach out to you? Can you tell me another reason why?
Well, I mean, I just, like I said, each time is, just to sit down and to breathe and to explore all of the options, mitigate the fear, and critically think and analyze your situation. Everybody's situation is different. And I think this also shows, and this is something that we can talk about on the subsequent podcast, is also you got to get a second opinion. You can't just rely on one U.S. tax compliance person.
If your gut is telling you something, especially when your gut is telling you something.
Yeah,
and even listen to that voice.
Right, and because it's so complicated, and if you don't know nothing from nothing, and it's like going to the doctor. You have a tumor, and they're giving you a course of treatment. Okay, but you got to get a second opinion.
Yeah, because you are really liable. Yeah, thank you so much. All right, so John, I'm just trying to figure out something. I'm trying to imagine a roadmap here, and let's just say that I'm a U.S. person abroad and I have a business. Where do you think my road would lead? Where do you think that would be?
Yeah, it's for this generation of Americans. It's clearly over. They've got to renounce, plain and simple. It's the only
because nobody's supporting them. You just said at the beginning.
Yeah, we just said in the beginning.
Nobody's supporting them, but they're not even supporting themselves.
Yes.
Well, that's true. The only.
Oh my God! There you go. There you go. There's How can you?
Right, and the thing is, I just had a woman on in the American Expatriates for Residency-Based Taxation group say, well, other issues are more important. Well, I had a few choice words I would like to have said, but I didn't. And it's like, if you don't stand up for your own rights, nobody else is going to.
Right.
There's always going to be other issues that are more important. Always.
I've been at this for years. You've been at this for years. Okay. The problem is not, I put a tweet up and I think it was something like this. When it comes to this, the problem is not America. The problem is Americans. Okay.
Yeah. Yes.
I think that more accurately captures it. You've got, American, the groups, forget the groups. They're not there to help you anyway. Okay. But you have factions of Americans abroad that really are, opposed to each other. And there's not enough people who understand that there's a great principle at stake here. There's a great injustice at stake here. And I think that individual Americans have a moral obligation to solve this problem once and for all, to end it so that it doesn't get passed down to the next generation.
Yep.
So Reagan used to always say, what is it? Freedom is just one generation from extinction.
Well, how many generations ago did we lose it? And I don't know, 1913 seems to be a bad year for many things. Anyway, if you are thinking about renouncing, what I would suggest is you do reach out to John at citizenship solutions at protonmail.com. Reach out to him there and he will really guide you through the process. Really, and if there's so many moving parts, you really need to have someone who gets the whole thing. And boy, I don't know who understands it better than John.
Any assets at all. Anthony, go to the last slide, okay? Just one more.
Yep, you bet. Yep.
FBAR thing here.
Yeah.
So I've been writing about this stuff for a really long time, okay? And a lot of, years, okay? And I've compiled my posts into something called the Little Red FBAR book. And anybody who's interested in really learning how this works, the history, the evolution, it's, I think, a great, great resource out there. I go through the complete history of the legislation. Just, tons and tons. It was never started out to be that way, but that's sort of what has been collected.
And here it is. And you can find the links in the slides. And the slides, you can find a link to the slides.
Yeah, if you just scroll down, it's posted.
Wow.
So it's, I think, well, the book itself, what was it? Was it 8 parts? I can't remember. I've done this over
8 parts. Yep. Really, and if you are a practitioner, you really, really need to check this out to get the real background of it.
Yeah, I think it'd be very, very helpful to lawyers who practice in this area.
Yeah, really helpful. And and I'll just say this. I know we're short for time, but I got to say this. one of the things that John properly pointed out is that 31 U.S.C. 5314 was not part of the Bank Secrecy Act of 1970. It was part of the Currency Control Act. It was later put into it. So people are saying like, oh, this was passed as part of the Bank Secrecy Act. No, that's not really what happened. And really, when you look at 5314, it is regulating monetary instruments or currency. It would make sense for that to be in the Currency Control Act, not a Bank Secrecy Act, because a bank is not mentioned in 5314. Foreign financial agents are, and foreign financial agents are individuals. They are not banks. They are not institution, and it's defined by the Bank Secrecy Act as such. So if now, I would just say in conclusion, I want to thank John. I want to thank Keith so much for everyone. I want to thank everyone for joining us today. It's been fantastic. And I just feel enlightened myself. I hope you guys do too. Another, what I would call this, another masterclass, John, another masterclass. That's what we have here. And I just want to thank you so much for what you've done for everybody here and illuminating us and bringing us together. And along with Keith is so responsible for bringing us together. I appreciate that. And if you are someone who's facing some issue, and actually, if you're actually just looking to support this channel, what I would say is that we are tax attorneys, and we also do tax preparation. We handle difficult international taxation. We really enjoy doing it. So if that's something you're looking to do, you need some tax prep, or you need a disclosure or something like that, you can reach out to us. It helps support this channel, keep it going, and inform everyone. Go to irismedic.com/offshore for any help with any international issue, including tax prep. I know we're coming up on the end, and if you are needing an extension, there is, if you're overseas, there's a permissive extension to December 15th, and there might be other ways to get a little additional time. So with that, I want to thank my great guests, and I want to thank our audience, and be sure to subscribe, turn on those notifications so you know when we're going live, so you can participate. We love the comments. And again, thank you so much, everyone, for joining us today.